Welcome to Chapter 12 of Law in Australian Society, which is the final chapter on counterterrorism. This is the second of two case study chapters which look at law reform in practice. In this chapter, you'll learn about Australia's legal responses to terrorism, including criminal offences for terrorism, expanded powers of police and intelligence agencies, the speedy enactment of counterterrorism laws by the Federal Parliament, and the impact of counterterrorism laws on human rights and freedom of the press. Since the 9/11 attacks in 2001, Australia has enacted at least 75 pieces of legislation in response to terrorism. This is far more than other countries, including those with a higher threat of terrorism, like the UK and France. Most of these laws were enacted by the Howard government in response to 9/11, the London bombings in 2005, and more recently, the threat from Islamic State and foreign fighters. So what is terrorism? There's no internationally agreed definition of terrorism, but most countries have introduced new definitions of terrorism into their laws. Australia's legal definition of terrorism can be found in Section 100.1 of the Commonwealth Criminal Code, and this definition was inserted in 2002. Section 100.1 defines terrorism as conduct or a threat which is designed to advance a political, religious, or ideological cause. This is known as a motive requirement, and is intended to influence a government by intimidation or intimidate a section of the public, and causes one in a specified list of harms, including death, serious bodily injury, serious property damage, or seriously interfering with electronic systems. Australia's counterterrorism laws have also introduced a wide range of criminal offences for terrorism. There is an offence for committing a terrorist act, but in practice this is much less useful. The main offences prosecuted in Australia for terrorism are what we call preparatory offences, so the main overarching offence for preparing an act of terrorism. It also includes financing offences, terrorist organisation offences, the declared area offence, and an offence for advocating terrorism. So all these offences really target very early preparatory activities before the normal law of criminal attempts would be triggered. Because of this, counterterrorism laws have often been referred to as a form of pre-crime because it's more about punishing somebody for what they are likely to do in the future than what they have done in the past. As in other countries, Australia's counterterrorism laws have also expanded the powers of police and intelligence agencies. In some respects, and because of the lack of formal human rights protection in Australia, Australia's laws go much further than those in other countries. Control orders are a civil order which allow the federal police to put a person under a number of restrictions and obligations. This is similar, I suppose, to bail and parole or probation, but the difference is that the person need not be convicted of or charged with any criminal offence. Preventative detention orders allow the federal police to detain somebody for up to 48 hours or up to 2 weeks under state legislation in order to prevent a terrorist attack or to preserve evidence in relation to an attack that just happened. Questioning detention warrants are a power held by ASIO, the Australian Security Intelligence Organisation, and Australia's Domestic Intelligence Agency. These are an extraordinary power which allows ASIO officers to detain somebody for up to a week for questioning. Importantly, this is for intelligence gathering purposes, and the person need not be suspected of involvement in terrorism. In 2015, the Federal Parliament enacted new laws which provide for special intelligence operations. These are specially approved undercover operations in which ASIO officers receive immunity from criminal and civil liability. And finally, also in 2015, new laws were introduced which require communications service providers like Telstra, Optus, Vodafone to retain metadata for 2 years. Metadata does not have a formal definition in the Act, but it relates to data about a communication, such as the time and location of a call or SMS message. This metadata can be accessed by enforcement agencies without a warrant. Some of the lessons from Australia's counterterrorism laws are set out in the book. The first of these is the importance of having adequate scrutiny of counterterrorism laws and all other laws in Parliament. The second is the impact of these laws on human rights. The declared area offence, for example, impacts on the presumption of innocence. Many other powers, like control orders and preventative detention orders, impact on the rights to liberty and a fair trial. And finally, many new laws introduced in response to terrorism impact on freedom of the press. There are many disclosure offences which prevent the publication of information that is sensitive for national security reasons. This is understandable because ASIO and the other intelligence agencies need to maintain secrecy for their operations to be effective. At the same time, the offences prohibit the release of information which might be significant and in the public interest. The key points from this chapter are that Australia's Federal Parliament has enacted at least 75 laws in response to terrorism. These laws have created new criminal offences and expanded the powers of police and intelligence agencies. These counter-terrorism laws in Australia are some of the most extraordinary in the world. This is possible because Australia lacks constitutional protection for human rights, as we looked at in Chapter 6. And finally, criminal offences for disclosing information about national security matters can restrict the ability of journalists to report significant information in the public interest. Given that we looked at the important accountability role of the media in Chapter 3, this is a significant problem. Some discussion questions to think about Australia's counterterrorism laws. Do you think these laws are a justified response to the threat of terrorism? How do preparatory offences differ from the ordinary law of attempt? What terrorist organisations are currently prescribed by the Australian government? And what can you find out about these organisations, such as their motives, tactics, and recent attacks? How does the declared area offence undermine the presumption of innocence? What kinds of conduct could fall under the offence for advocating terrorism? And do you think it should be a crime to post material online that supports or promotes terrorism? How do control orders differ from bail, probation, and parole? How significant a risk do the metadata laws pose to our right to privacy? How much private information can metadata reveal about our lives? And how could Australia's counterterrorism laws be amended to provide greater protection for freedom of the press?